a lot of what I'm going to talk about depends very much on state law, and unfortunately, every state's a little bit different. So I'm going to talk a lot about broad general concepts. I'll try and make it as relevant to personal situations as I can. And some of this, I fear I'm going to be preaching to the choir, because just in little conversations I've had this morning, I suspect a lot of you have already done some of what I'm going to be talking about. So if I'm going a little bit more basic than some of you may want to hear about, I'm sorry, but I hope I'll put something of a big picture together. The basic concept of what I want to talk about here in planning and how to handle asset protection is this. Competent adults can make their own financial decisions, their personal decisions. Today, I can handle my own medical affairs, I can pick my doctors, I can decide what I want them to do, I can handle my own financial affairs, manage my money, and I think I'm doing pretty well. My wife might dissent on that, but I can do that pretty effectively. There's going to come a time when I can't do that anymore. Obviously, it's when I die. I can't take it with me, and I can't from the grave decide what's going to happen to my assets or money. Another time that that's going to happen, probably, actuarially speaking, is if I become seriously ill or incapacitated. Aging, serious illness, strokes, accidents cause people to become incapacitated and cause them to become unable to handle their own affairs. Advanced planning, estate planning, provides for personal management, medical care, management of financial affairs, and disposition of assets when the person can no longer do it for themselves. Right now, everybody here has an estate plan. You really do. It might not be the one that you wrote. It might be the one that's in the codes and the statutes of your own individual states. The plans are set out in state law. It's set out for estate administration, what you all may hear about or refer to as probate. It's set out for adult guardianships, guardianships of the person for medical care. It's set out for financial management if you become incapacitated. It's set out for what happens to your money. Intestate succession means if you die without a will. And it happens for financial management, guardians of property. So if you have an estate plan, why are you going to listen to me for the next hour? Because the plan that's in the statute may not and probably won't meet your needs. One size doesn't fit all. It works for baseball caps and socks. It doesn't work for estate planning. It's also cumbersome and inflexible. It's cookie cutter. It's likely to be much more expensive if you have to work through what's in the state plans. Personal affairs are subject to government agency control. You have personal autonomy. Your private matters become public. And I'm forgetting to get to these slides. There we go. Sorry. And that's troublesome for a lot of families. A lot of family disputes are not a result of somebody being a bad person. A lot of it's just recent disagreements in very important matters, and you don't want to air those grievances in a public courtroom. And asset protection, and this is particularly critical for a lot of what you all are worrying about, adult protection is incomplete or it's completely inadequate for what you need. It's especially important when you're thinking about a child or a disabled individual. There's a paradox in state law. Judges, courts, have a tremendous amount of power to do a lot of really, really intrusive things and control a lot. On the other hand, they have very little power over some very important matters. And therefore, you want to take control yourself. The way you take control is from a variety of different planning documents, financial powers of attorney, what are called advanced medical directives and powers of attorney for health care, a will or a trust, and a relatively new a program called a standby guardian for a minor. There's also something very, very new called supportive decision making, which I'll talk about in a minute. Let me tell you, advanced planning is a gift that you give to your loved ones. You will have no idea how much benefit you can do by putting together a thoughtful, comprehensive plan, and how much that will avoid difficulties and how much that will help your loved ones who you might leave behind or who might be dealing with you if you become incapacitated. Let me talk a little bit about terminology. One of the concepts that's really important is this concept called capacity. Capacity really means your ability to make your own decisions, to understand a transaction, and to be able to communicate what it is that you want to have done or not done. Capacity is the legal concept that most people use. It does not mean incompetence. Incompetence is when you completely can't do anything. Capacity is a different concept. We're going to talk about that in some detail as we go along. And capacity is really something that's issue dependent. It depends on what it is that you're going to be talking about. Capacity to make a medical decision is different than capacity to manage a stock portfolio. Another concept that we're going to be talking a lot about is this concept of what's called a fiduciary. And depending on what document or what structure you're dealing with, the label is going to be different. There's going to be an agent under a power of attorney or a personal representative of a decedent's estate. You might be used to hearing terms like executor or administrator. The more current term is personal representative. A trustee under a trust. A guardian or a conservator. Those are all fiduciaries. And the concept of a fiduciary is somebody who manages either the medical affairs or the financial affairs of somebody else. And we're going to talk a bit more about specific fiduciaries and specific roles as we go along. The whole concept of this advanced planning is to put in place a structure to provide for these individual needs: healthcare, personal management, management for financial affairs, and protection of financial security for you and for your family in the event of your incapacity. And there's two categories about this. It's when you're dealing with disability or some kind of incapacity, and then dealing with these issues after, particularly financial management issues after death. These objectives are met by a financial power of attorney. If we're dealing with incapacity, we'll talk about that category first. That's dealt with by means of a financial power of attorney or an advanced medical directive power of attorney for health care, what people used to talk about for living wills, and that's not a phrase that you're going to hear very much about anymore, or a trust. So let's talk about powers of attorney for a second. A power of attorney is a fancy term for a very simple concept, and it's the concept of agency. What does that mean? How many of you have bought a house or sold a house? A lot of you. You dealt in what the law calls a principal and agency relationship. You hired a real estate agent. You said to the real estate agent, I want you to sell my house. Or I want you to go out and I want you to find me a house. And you gave the agent some instructions. You said, I want you to sell my house for X number of dollars. I want you to sell my house within a specific period of time. I want you to find me a house with a fireplace or whatever particular interest you have. The agent goes out and does what you instruct the agent to do. Easy. Everybody understands that. A power of attorney is a document where you create for yourself a principal-agency relationship. You're the principal, and you appoint somebody as your agent, and you direct the agent with what to do, either orally or with powers of attorney in writing. It's easy. Everybody understands that. A power of attorney can be for a specific purpose. The real estate agent who sells your house for you if you have to go overseas for a year, or a much broader general power of attorney, and that's probably what we're going to be talking about here. Okay. There, I missed it. There are two different concepts of powers of attorney. One concept is a durable power of attorney. And durable means it's something that lasts. The classic idea of agency 40 years ago was you had to have a principal, and the principal had to tell the agent what to do and supervise the agent's carrying out of the principal's instructions. And if the principal wasn't around to do that, you couldn't have an agent. So if the principal died, the power of attorney ends. If the principal became incapacitated, the power of attorney ends. Well, wait a minute, that doesn't work very well, because if you become incapacitated, the whole idea of getting somebody to handle your affairs for you won't work if it ends if you become incapacitated. So they create this concept of durable powers of attorney, which allow the agent to continue to work even if you can't supervise and specifically direct the agents. You do that in writing in advance. The other concept is the concept of a springing power of attorney. So if I sign a power of attorney today and I say, I appoint my wife as my agent under the power of attorney, she's my agent and power of attorney. She can start running around doing things for me. I may not like that very much, and I may want to say, nah, not yet. A springing power of attorney comes into being when I say it comes into being. It can be on a specific date. Common example, somebody's in the military, they get posted overseas, they're going to be overseas, create a power of attorney, and they say, when I ship out, you're in charge, but don't do anything until I leave. For your purposes in advanced planning,
Can you replace your batteries?
what?
We're losing your microphone.
Oh, okay.
1 second. Sorry, guys. Closer to yourself.
All right, are you all still with me? Okay. So a springing power of attorney for this advanced planning notion is that it becomes effective upon your disability. When I become incapacitated, either a court certifies that or a doctor certifies that I'm incapacitated, then the agent has the authority to begin to act. Whoops, there we go. The first decision and the most critical decision that you're going to make when you start talking about powers of attorney, putting them together, is who's your agent. And now we're back to this concept of a fiduciary. The point you want to keep in mind is that you're hiring, you literally are hiring somebody for a very important job. This agent's going to have a great deal of responsibility. They're going to be expected to make very important decisions, and they're going to have a whole lot of authority. There is, in my profession, another term for powers of attorney. That term is license to steal. I don't want to scare you off and tell you not to do these things, because that problem exists for almost any advanced planning document you do when you appoint a fiduciary. That person is going to have a lot of authority to do a lot of things, and if the person isn't trustworthy, isn't honorable, they can do some really bad things. So when you're making this hiring decision, when you're figuring out who you're going to put in your document as your agent under your power of attorney, you need to name someone who you have a great deal of confidence about, a great deal of trust in. It's not, well, gee, Johnny's my oldest kid, so I'm going to make him my agent under a power of attorney. Or, gee whiz, my brother-in-law knows real estate, I'm going to make my brother-in-law my power of attorney. Doesn't work that way. You want to give a lot of very, very careful thought to that. So what do you want to think about when you're doing this naming of your agent, your hiring decision? You want to think about what task the person's going to be required to do. The more complex your personal affairs or your family affairs are, the higher the level of need that person is going to be expected to make. Does he have or she have the ability and the temperament to do what's required? Are they going to be readily available? Is somebody living locally? Are they across country? With Skype and all the internet stuff that goes on, it's easier to deal with long distance, but it still could be a handicap. Can they obtain or do they have the ability to get needed assistance? Do they have a conflict of interest that may be a problem? What's a conflict of interest? I'm the trustee, and I'm also the end beneficiary, I get what's left over, but I have to make decisions and make distributions for the beneficiary during the beneficiary's life. Do I want to make distributions now to that beneficiary? No, I have the money that I'm going to get when the person dies. That's a conflict of interest situation. In this area, I joke with my colleagues and with the judges down in court that they ought to put a sign on the building that the probate division is in that says, Probate Division, conflicts are us. Because inherent in this process is these conflicts of interest. If your spouse is your beneficiary under your will, and your kid is following, are you going to make your spouse the personal representative? Of course you are, almost certainly, but that inherent conflict of interest exists. The issue is whether or not the conflict of interest becomes so great and so prohibitive that you need to think about somebody else. There's a concept called a surety bond, and I'll talk about that in a little bit detail later, but it's basically an insurance policy for the agent. Can the agent be bonded if that's going to be required? Most insurance companies have underwriting standards, and the agent's going to have to be able to meet those underwriting standards. You can select anybody you want. Spouse is pretty common. Adult child's pretty common. A trusted relative and friend is pretty common. A financial advisor or an attorney, depending on the magnitude of the work that needs to be done or the assets that need to be managed. And by the way, it doesn't have to be the same person for all these documents. You don't name your spouse necessarily, or you don't have to name your spouse or your adult child to be your agent under your financial power of attorney, your agent under your healthcare power of attorney, the personal representative under your will, and the trustee under your irrevocable trust. It doesn't have to be one size fits all. Remember, you're hiring somebody and you want to hire the person who can do the specific job. And each job is a little bit different. So let's talk then about financial powers of attorney. And here's where it gets a little bit difficult because every state is a little bit different about this. I will tell you, however, that particularly for financial powers of attorney, there are some uniform laws. There is a Uniform Power of Attorney Act that basically creates a statutory form power of attorney. It goes on for pages after pages after pages. And it's actually a good concept to use because people move around a lot. You can live in Maryland today, you can move to Pennsylvania tomorrow, and, depending on your age and your station in life, you may get a job in Chicago, and oops, there you go. Do you have to redo documents all the time? Sometimes you might have to if state law is different, but if you have a uniform law, it might make it easier. These standardized forms end up putting an extensive list of powers that are granted to the agent, and you probably want that. Because in essence, what you're doing is if you become incapacitated, unable to handle your own affairs to some degree or entirely, you're creating essentially an alter ego you who kind of stands in your shoes and becomes a substitute you to make almost every decision that you could make for yourself. They can't write your will, but they can come pretty close to doing just about everything else. You can have a limited power of attorney that restricts some of that, and that may be appropriate in certain circumstances. There's a general concept that you need to keep in mind as you're doing this advanced planning and as you're putting in the specifics of the power of attorney. By the way, with these statutory forms, you can't tailor the form, but you can add stuff at the end or actually make a separate ancillary power of attorney to have specific instructions for your own unique circumstances. And this is where this comes into being. As a general rule, your agent is supposed to use your assets for your benefit. That doesn't always work. For example, if you become incapacitated and you and your wife have been working, or your husband has been working together and sharing your resources and all of that, you kind of don't want to have the agent divide that all of a sudden. Or if you have your separate income for some other reason, pension, separate business, for example, separate investments is very common, you don't maybe want your agent to be limited in what your agent can do with that. In other words, the agent shouldn't necessarily have to be required to use your assets for your own purposes. Oh, gee, what happens if you have a child, a minor child that needs care, or, as many of you are probably experiencing, as I'm hearing today, a adult child with some level of disability who's going to be dependent on you past age 18. So you need to make sure that your power of attorney provides for the agent to have authority to do things with your assets for other people. And you can be real specific about that. I want my agent to hold on to my real property and to provide a residence for my surviving spouse and my kids. Don't sell it unless you absolutely have to. I want my agent to make sure that money is used for a specific purpose. If my child needs specific therapy purposes, the agent has to make sure that the child gets that. The agent can have authority to transfer assets into a trust. Maybe your own trust, maybe a trust that you set up for a spouse or a disabled child. It's especially important to look at those needs when you're dealing with an incapacitated spouse or a disabled child. And so you need to have detailed conversations with your planner, who's going to be working with you to put these together, to make sure that you've identified specific needs and that your power of attorney specifically allows those needs to be met. This concept of a gift is part of what I was talking about, in that your agent is supposed to use your assets for your benefit, can be instructed to use assets. The concept of a gift is when assets are transferred to somebody else for less than full value. Okay, usually it's with no value at all coming back, but it's less than full value. Christmas gifts nobody cares about, but if you're going to take a substantial amount of money and move it to somewhere else for somebody else, you may want to do that yourself, and a lot of planning techniques do that. You may want your agent to have authority to do that. That's a gift, and you need to specifically address that when you're dealing with planning. Putting money in a trust, particularly an irrevocable trust, can be considered a gift. Again, identify needs and make sure that they're met. Other specific issues that you can deal with are, pardon me for not keeping up with this, you can designate a person if for some reason you have to have a court-appointed fiduciary, a conservator or guardian of your property, or a guardian for your person, a healthcare guardian. And you have to go to court to get that for some weird reason. Your plan for some reason needs some help. You can designate a person that the court should appoint, and you should do that in a power of attorney. You can decide when the power of attorney can become effective. Is it springing, or is it effective when it's immediately signed? And you can define how incapacity is determined. You can set standards. You can decide whether it's one doctor, two doctors, a doctor and a clinical social worker, or a psychologist, and so on. And again, that's not cookie cutter. You need to pay a little bit of attention to that. The next document we're going to talk about is what's called an advanced medical directive, or a power of attorney for health care. Today, you can pick your own doctor. You can listen to your doctor. You can say, yes, go ahead with that procedure, or no way, don't do it. You can decide if you want to take certain medication. You can decide if you don't want to take certain medication. What happens if you can't make those decisions yourself? With a healthcare power of attorney and advanced medical directive, you name somebody to make those medical decisions for you, and you set out the manner in which those decisions are made, and you set out specific instructions for specific decisions. So let's talk about each one of those. Naming the person, we've talked about naming fiduciaries. Here, who can make my medical decisions most effectively? True story. In my family, I'm the lawyer, supposedly I do this sort of stuff in managing people's affairs in the States and so on, but my sister is meticulous. Her career has been as an administrative assistant in different companies for the executives of different companies. She is meticulous. She dots every I in blue or black ink. She was perfect for handling when my mom started to get a little bit needing some help. She was perfect for managing my mother's financial affairs. My sister doesn't do well under stress. Stressful situations sort of cause her to get stressed herself. And her reactions to stress are not always the most positive. So when we're standing in a hospital corridor and the doctor's going, I need to know now, that's not where my sister needs to be. So when it came time to do my mother's planning, we gave different people different jobs. That's what I was trying to communicate before. How you make those decisions for healthcare purposes is a concept called substituted judgment. And what that means is this. Substituted judgment is, what would Ed do if Ed was here and able to make the decision himself? How are they going to figure that out? They're going to make my agent's going to make a good faith effort to try and figure out what I would do if I could speak and say what it is that I want done. If after a good faith effort to figure out what I would do and apply what I would do, not what my agent thinks is the right idea, but what I want to have done, if for whatever reason that can't be figured out, then the law says you apply the best interest standards. And the best interest standards at that point is my agent's determination of what ought to be done, considering the specific risks, the benefits, the burdens, the course of treatment. Does it make sense to do something, withhold treatment? Is that going to be good for me? But it's the agent's decision of whether it's going to be good for me rather than my decision of whether it's going to be good for me. So how do you do this substituted judgment thing? You now tell people what you want, okay? And you will be amazed on how difficult some people find that. Talk about it. For goodness sakes, we're all going to die. Not right now, but eventually we're all going to die, and everybody, actuarially speaking, is likely to need help at some point along the way. Accident, injury, old age. Talk about what you like, what you don't like. Give instructions to people. I read something, and it's not quite as facetious as this, but last night my kids and I were sitting in the living room, and I said to them, I never want to live in a vegetative state, dependent on some machine and fluids in a bottle. If that ever happens, pull the plug. My kids got up, unplugged the computer, and threw out my beer. You want to be a little bit more exacting than that. You don't have to have this discussion at Thanksgiving dinner table. It's kind of a downer maybe, but do get people together, your loved ones, and say, you know what, this is kind of what I like, and this is what I don't like. This is what my aspirations are. And everybody is different. Believe me, I do this for a living, and everybody comes up with their own ideas, and what works for me isn't going to work for you, and what works for you isn't going to work for you. It's just not. So be specific about that. You might want to include in your power of attorney, if I haven't spoken about this in detail enough for this specific decision, think about my religious beliefs, prior medical decisions. What did I do when something was like this before? Think about my personal values. Am I somebody who, just doesn't like to sit and won't sit, as opposed to somebody who doesn't mind being hooked up to things if need be? Talk about other people who might know what I want. Family members, other family members, clergy, close friends. They're discussions that people have with their good golfing buddy as opposed to their spouse. So think about that if you're an agent needing to make decisions for substituted judgment decisions for somebody else. And you can, in your healthcare power of attorney, say, before my agent makes a decision, I want my agent to consult with. So if I have 3 kids and I name one of my children to be my agent, I'm going to say, talk to your siblings before you decide on surgery or chemotherapy or anything else. If it's an emergency situation, sure, no, go ahead and do what you need to do. But if you got some time, talk about it with your siblings before you make the decision. Specific issues that you can address. Should the agent move heaven and earth to keep you in your own home? Or is it okay to think about senior living, assisted living facilities, and some? Different people have different philosophies about that. What about hospice care? Do you want to put that off or bring that in as soon as possible? Experimental treatment or procedures. That's becoming more and more prevalent now as medical science advances. You guys are hearing about some of that today. Gene therapies and cancer treatments and so on. Some of that's experimental. Think about what you might want to do about that, and you can provide that in advanced instructions. Anatomical gifts, organ donations, consent to or withholding consent for autopsies, cremation or not. If you want cremation, you should specifically authorize that. And then you get into the whole category of end-stage decisions. That used to be called the living will. What happens if I have a terminal condition or if I'm comatose and I'm not going to wake up? What happens if I'm in what's called an end-stage condition? Advanced Alzheimer's is an example of that. And you can provide specific instructions for that. It's what people somewhat oversimplified talks about, do you want them to pull the plug? Well, it's a good deal more elaborate than that. What about things like making a choice between pain management as opposed to treatment? Think about that. What about things like artificial nutrition and hydration? When do you stop that? When do you start it? Do you start it at all? And you can provide those instructions. And again, that's something that you need to think about carefully and be specific. P.J. O'Rourke, who's a humorist, wrote, "A living will should be very specific about the definition of brain dead, and not so carelessly worded that it can be implemented by greedy heirs if your foot falls asleep." Be specific about that. And think that through and talk to your relatives about that, your children about that, your spouse about that, because they may have some ideas about that as well. It's uncomfortable, and I know that from my own family experience. I know that from dealing with families. It's uncomfortable to talk about that. We're not so good as a society to deal with these sorts of things. We need to be better about it. Thomas Jefferson was reputed to have said that death is like being caught in the shower. It's not an event to be hoped for, but it's not an event to be greatly feared either. You don't want to die, but you're going to die, so talk about it. You don't want to get sick, but you're likely to be sick. Talk about it. And I have to tell you from somebody who gets involved with families like that, the most agonizing thing to do is to sit and listen to 3 kids talk about what's going to happen to mom and just have conscientiously legitimate, good faith differences about that. Mom would have wanted this. No, mom would have not wanted that. And they really feel genuine love and concern for their mom, but they can't agree, and that's agonizing. That's the gift that you can give by taking away that decision. There's a relatively new thing going on, which is a standby guardian for a minor. Did I skip that? Yeah. That's by state law, and some states have this. What that allows you to do as a parent is to create a custodial relationship, somebody having custody of your minor child, if you become disabled through illness or injury, to be able to care for your child. And it's designed to be perhaps a temporary arrangement. If you, for example, have a chronic illness that you go up and down, and sometimes you're in the middle of a course of chemotherapy and you're not really able to do things very much, then that stops and you're doing okay. Certain other illnesses are like that. You can create these standby guardian relationships where you designate somebody to step in to be a substitute parent, and give them instructions about that. This does require court approval for either in advance or once the standby guardianship kicks in upon your disability, the standby guardian has to get court authority within a certain limited period of time. It's not a surrender of parental rights. It really isn't. And the standby guardian has to act consistent with your instructions. For those of you who have minor children who you're particularly concerned about, this is a very good device if your state has it, to put in place in case there's an auto accident and you're in the hospital and can't do anything for 2 or 3 months, or if you have your own medical needs and you need somebody to step in for you. Think about that and ask lawyers in your local states as to whether or not you can do that. You cannot make these plans for competent adults or even incapacitated adults. Minors are different. Minors, parents can make decisions for, but adults you can't. I don't have a slide for this. This is a relatively new thing. Ignore that for a second. But there's a new concept, a very new concept. DC just passed a law about this less than a year ago called supportive decision making. And here's how this works. If somebody has some diminished capacity in some respects, they may have some learning disability, or they may have some limited cognitive limitations, but they can still generally do most things. They can put together a supportive decision-making contract. What does that mean? Here's an example of where lawyers take a common sense, easy, everyday concept and make it complicated. How many of you have ever bought a house, sold a house? How'd you decide what to sell it for? You just did the supportive decision making. You went to an expert, somebody who knows more than you do, and you asked for advice. Did the real estate agent decide whether you should sell it for that price, or did you? The real estate agent gave you advice. You made the decision. You did supportive decision making. And you did it by means of a contract. You signed a listing agreement, right? There you go. That's supportive decision making. So if you've got a relative, an adult child, who you think might be able to do some things, see if your state has this kind of provision. And it works like this. You write a contract, you name your child or you yourself, name somebody to be the supporter, the assistant, and you give that person certain ability to help you out and maybe to do certain things. Write my checks, but make me sign them. Okay? Bring me to the doctor. I make the medical decisions, but you can sit there with me and help me understand what the doctor is saying to me. Okay? You can help me make decisions about where I want to live. If there's a need for some residential living, assisted living, group home, that kind of thing, help me decide where I want to go and how that could be structured. You don't. This is the alternative to the court guardianship for your disabled child. Your child has to do it. Your child has to have the capacity to do it, but you can encourage your child to put these things together if you want. Okay, let's talk about the financial piece of it, and this is the court-appointed guardian or conservator. Think of it in these terms, and different states use different language, by the way. When you talk about medical care, it's usually called the guardian of the person. For the financial part of it, it's called either a guardian of the property or a conservator. I'm going to use the term conservator because that's what I'm used to using, but it's the same concept. A court-appointed guardian conservator is going to be required if there's no advance plan, the advance plan is incomplete, it doesn't address specific issues, or it's not working properly. The agent has gone off the rails or can't handle it, or you're going to probably be looking about a court-appointed guardian or conservator if the person lacked the capacity to do an advance plan. If you or a loved one just doesn't have the cognitive ability to put one of these together, you're going to have to deal with a court guardian or conservator. For minors, if a minor becomes entitled to money, you have to deal with a guardian of the assets of the minor. Minor can't hold property, him or herself, in their own name. This is very much a state law situation, and it varies tremendously from state to state. So all I can really do here is talk about general concepts. For adult guardianships or conservatorships, guardianships of the property, they're called intervention proceedings in the more modern statutes. And that label makes sense because what it is the court is intervening in the private affairs of somebody else, okay? Either medical affairs or their financial affairs. Intervention results in the loss of personal rights. You have the right to make your own decision. A court-appointed guardianship or a court-appointed conservatorship takes away your right to make the decisions and gives it to somebody else. And therefore, a higher standard of proof is required before a court can take away your legal rights. And incapacity is the threshold for that determination. The court has to be shown that you are incapacitated. And here's where this becomes important. Incapacity is a functional test. It's not an on-off switch. The light's on, the light's off. The light's on, the light's off. Think of it as the dimmer switch that you got in your dining room. As you turn it down, the lights are a little bit less bright, a little bit less bright, a little bit less bright until they're out. That's the concept of incapacity, because some people can do some things okay, but they can't do other things. Somebody who can't manage a large stock portfolio can probably do pretty well in deciding whether or not they want cable. Okay? So it's not an all or nothing proposition, and therefore, when you're talking about what the court should be able to do, the court should only get involved to the extent that the court's involvement is needed, to the extent that there's an incapacity that has to be addressed, and that's a critical point. The nature and the extent of the incapacity determines the outcome of the proceeding, because the more modern statutes require the court to impose the least restrictive alternative. And here again, they're supposed to apply a substituted judgment standard, and the subjects or the ward's views should be taken into consideration to the greatest extent possible. Okay? Because it involves a loss of rights, this process you just need to think about in terms of certain procedural protections. The right to notice, service of process is essential. The person involved has to get a copy of the petition to get a conservator or guardian. There's a right to be heard. Somebody who is incapacitated and needs help can still, in many cases, speak and have some judgments themselves, even if it's only, I want my mom to be my guardian. If that's as far as it goes, the court's still supposed to listen to that. And therefore, there's a right to counsel, because the right to counsel is what affects the procedural protection. Make sure those procedural protections are honored and helps the person speak for themselves. I'm not going to spend too much more time on this concept of procedures, the least restrictive alternative, other than to suggest that this least restrictive alternative allows you to press standards and limitations on the guardianship, or specific instructions on the guardianship. And those of you who are grappling with this as you're thinking about someone acting as guardian for your child, you may do it now, but that may not be the permanent thing forever and ever and ever. You're older than your child, and actuarially, you may outlive your child. You may not, but you may. And therefore, you can put in specific provisions about certain therapies, certain types of assistance they're required, talking about living at home or group home situations and so on. And that can, and those requirements, those limitations, can be included in the court order. And I've listed some of those in the material that I passed out to you. I'm going to skip a little bit just because we're running a little bit out of time. One thing that you do need to bear in mind is that when you're dealing with a court conservatorship or guardianship, there's a lot of court supervision, a lot of court requirements. And that's a good thing because it's protective, and that's a bad thing because it's protective. and it can be really intrusive. You don't have to be a conservative Republican or a Ronald Reagan fan to understand that there's a lot of truth when Ronald Reagan said the most scariest words in the English language are, "I'm from the government and I'm here to help you." Because if it's not put together correctly, a court conservatorship or a court guardianship can be tremendously, tremendously intrusive. Everything is public because it has to be filed. Your accountings have to be filed. The medical supervision that the guardian exercises has to be reported to the court. And that's all public documents because people look at what courts do and want to make sure the courts are protecting vulnerable populations, incapacitated adults, incapacitated minors, and minors whose parents are not able to effectively manage their own assets. So you want to be careful about what the guardian does, but once it's in place, there is court monitoring, and you're allowed, if you're not the guardian yourself or the conservator yourself, to watch what the person does. You're entitled to, as an interested person, get reports, get annual accountings, make sure that things get done that are supposed to be done, make sure that things that aren't supposed to happen don't happen. The courts are doing a better and better job of supervising this. It used to be pretty controversial, and it still is in some states, but they're doing better and better about it. But some type of parental or relative involvement is important, and as you're putting this stuff together, include that in there. If I can't do it, and I have an adult child or my child's aunt or uncle, they need to be involved. And they need to get these reports, and they need to be able to read them and say something about them. Guardians of minors are kind of special, and here's the tension, so you understand what happens. As a general concept, parents provide food, clothing, and shelter for their children. Children do not provide food, clothing, and shelter for their parents. One of the tensions that frequently exists in guardianships of minors is a minor gets a whole bunch of money, an inheritance, money from a personal injury action or medical malpractice action, and they need a guardianship, and the parents appointed the guardian, and the parent holds the money, and oops, all of a sudden the money's used because the mortgage is late, we need to pay the mortgage, or there's a trip that we need to go to, and it's good for the minor, but it's good for us too. And guardianships of minors, the guardian isn't supposed to be using the minor's money for the guardian's benefit. Parents provide food, clothing, and shelter for their kids. Kids don't provide food, clothing, and shelter for the parents. So as a result of that dynamic, and unfortunately it does happen, doesn't happen all the time, many parents are very dedicated and very sincere and wouldn't even dream of taking a farthing from their kid, even if they could. That doesn't always happen, and as a result, courts tend to be very, very, very restrictive about guardianships of minors. If you can come up with some alternative for that, and we're going to talk about that in a minute, you should. So now we're going to get to asset protection in the event of death and sometimes while you're alive. There are several ways to pass ownership or pass title to property. A gift. It's easy. I give $10,000 to my kid. Or I give $10,000 to the college to which my kid is going to. That's a gift. Distribution through a trust is a way to pass title. Probate, administration of a decedent's estate, is a way to pass title. Property moves from the ownership of the decedent to the decedent's heirs or legatees. Designation of a beneficiary. Some of you may have IRAs, some of you may have 401k plans where you name a beneficiary to that plan. Life insurance, many of you may have life insurance where you name a beneficiary. That's a way of passing ownership to title. Yes, ma'am.
Talk about life insurance. I purchased life insurance for her when she was little.
Uh-huh.
And we did it, and we had a paid-up policy because we weren't able to keep up with the payments. But once she got older and became on Title 19 Medicaid,
Uh-huh.
They're only limited to $2,000 a year. Well, that created a problem then because they considered that as cash.
Hold that thought. That's a very important thought. I'm going to get to that, okay? Another way to pass title is joint ownership with right of survivorship. Many of you who are married probably own your property, your home as tenants by the entireties. That means that or a joint tenant with right of survivorship, when one owner dies, the other one automatically becomes the owner of the whole thing. That's the concept of passing title. Title can pass by will, by probate, or it can pass automatically by operational law. Survivorship designation, joint ownership, pay on death accounts, and so on. Some states have a specific provision for real property, some of the older forms of estate administration, where real property passes automatically, as soon as you die, it belongs by title to your heirs as defined in state law or defined in your will. The phrase that you will hear is real property drops like a rock from you to your descendants. That's not a good system, and you probably ought to try and avoid that if you can. Property that passes through a decedent's estate is probate property, and probate property is property that you hold title to that doesn't pass any other way. It doesn't pass by right of survivorship, doesn't pass by beneficiary designation. Probate, the term probate, is the admission of your will that gives to probate. It gives it legal force and effect. It governs how the estate is administered. Your estate is administered by a personal representative or executor or administrator. If you don't have a will, your assets pass by the cookie cutter to spouse, then to kids, then to parents, then to siblings, and that may not be the best way to do it. Estate administration is usually subject to supervision by a court or register of wills or some similar official like that. Some states call it an orphan's court. A well-prepared will can prevent and avoid many, many difficulties or problems in estate administration. A properly prepared will designates a personal representative, defines the powers of a personal representative. This went away. Help. I'll keep talking, and they'll catch up to me. I don't know what happened. It says we need to connect to guest Wi-Fi, but there you go. Thank you. I pushed the wrong button, I guess. Properly prepared will defines the powers of a personal representative, provides for payment of funeral and burial costs, and disposition of remains. There's usually in state law a limit to that, and those limits are usually ridiculously low. It can name the person that you want to have care and custody of your minor child in the event that you're the last parent living and they're still a minor child. It names the beneficiaries of the estate and can provide specific arrangement for asset protection, which we're going to talk about in a second. I want to talk a minute or two about trusts, because trusts are really, really fun. Trusts are the miracle documents that solves lots and lots of problems. What's a trust? A trust is a creative means of holding property, providing asset protection, and determining when and how property is distributed to beneficiaries. It can provide for administration of assets upon disability. It can provide for distribution of assets upon death or even before death. It is a private arrangement. It's a contract between the grantor and the trustee. It does not require court approval. The trust administration is not subject to court supervision. It's therefore a whole lot better and usually much cheaper than formal estate administration. So how does this work? Okay. The concept of ownership of property is, if you think about it, it's a bundle of rights. You hold title. Those of you who bought cars got a certificate of title. That said you own that car. When you bought a house, you got a deed. The deed said you own the house. Good, you have title to the car, you have title to the house. That gives you the right to use the property, to enjoy the benefits of the property, to manage the property, to direct how the property is going to be used for your purposes or others. You can hold the property for a limited time or for life. You can pass title to somebody else, either by gift or by sale. The concept of a trust is to take all of those rights and to break them apart. So you take ownership and you put it in the name of a trustee. The trustee holds and manages the property not for the benefit of the trustee, but for the benefit of beneficiaries. The beneficiaries enjoy the property or the benefits of the property. So you've separated this out, okay? The beneficiary enjoys the benefit of the property, but doesn't own the property, and that's a really important concept, okay? The beneficiary doesn't have any rights other than the rights that's provided in the trust instrument, and at some point the beneficiary may get property outright free of trust. A trust established by a grantor transfers ownership into a trust completely, creating an irrevocable trust, or a grantor can put ownership of property less than total ownership, which is called a revocable trust. And a grantor can act in multiple roles at the same time. The grantor can also be the trustee and can also be the beneficiary. Ooh, that's fun. Because what that allows you to do, and this is where if you hear late night television and you see the ads that says, avoid probate, come to a seminar and I'll tell you how to avoid probate, what they're talking about is trust. Here's how it works. If you create a revocable trust, you can create a vehicle for property management in the event of your disability that works a little bit easier and a little bit more effective than a power of attorney. You'll still need a power of attorney because there's some legal rights that a trustee can't exercise for you, but you can put as a grantor your property in trust, in a revocable trust. You can name yourself as the trustee who manages the property for the benefit of you, the beneficiary, and anybody else you name in the trust as beneficiary for life. You exercise the rights of ownership, but you've passed title to a trustee, and therefore, upon your death, title has already passed. You don't need estate administration. You don't need to administer a probate estate. And if you become disabled, you can't be your trustee anymore. In your trust document, you've named a successor trustee. If I can't be trustee anymore, I want my wife or my husband to be a trustee. If they can't be the trustee, I want my financial advisor. I want my middle son, whoever. Well, you become disabled, the doctor certifies you as being incapacitated and unable to make your affairs, and you define how that comes into being, then automatically the successor trustee comes in. You've just done the asset protection that you need to do, and in your trust, you can provide all of those important asset protection things that you want to provide. How to handle needs of a disabled child, an incapacitated adult, how to use property for the benefit of someone other than yourself. It works like a power of attorney, and upon your death, the trustee is managed for the benefit of the successor beneficiaries, your spouse, your child, and at some point, the assets are distributed outright and free of trust. In this way, it works just like a will. An irrevocable trust is a trust that you can't change. A revocable trust you can change. If things change, you can amend it, you can replace it with a different trust, and so on. An irrevocable trust, once the property is put in trust, it's not yours anymore because you've given up that string to pull it back, okay? And it can be modified, therefore, only under very limited circumstances. Irrevocable trusts are established in wills. You may sometimes see a will where there's a provision for what happens to your assets if you die and there's a minor child. That's a testamentary trust created in a will, and that's an irrevocable trust as well. So, asset protection. What you want to do and the law allows you to be very, very flexible on this, is balance the needs of all of the people you leave behind. Your surviving spouse, your adult child, your minor child, and you can do all sorts of things to make that asset protection work. And you can address a lot of different situations. Blended families is a very common one. Dad has kids from a previous relationship, mom has kids from a previous relationship, they get married. You got to work that out sometimes. You can deal with your future incapacity of your spouse, incapacity of your child. You may want to deal with situations where you have to have a disproportionate allocation of assets. I have 3 kids, and each one of them was different. If one of them liked ice skating, and those ice skating lessons were expensive. One of them really, really liked sports, and he went to sports camp. One of them was really into music. Well, none of them, in some ways, fortunately, needed an Olympic coach or go to the specialized schools for athletics or the trained musician to teach my child to be the next Mozart. But all of those things were expensive. Suppose one of them really was the child prodigy, or one of them really was going to be the next Olympic ice skater. As a parent, I would probably have provided for that. Am I cheating my other kids? Not really, no, because I'm going to try and meet their needs too, but needs is different for each child. You probably are addressing situations in your own circumstances where you've got a child that has some special needs that require special attention. Your trust is a very creative way of allowing you to address that. You can deal with assets of high value or unique characteristics. You can deal with estate tax situations. I'm just ticking these off to give you things to think about when you talk to somebody who's going to help you putting these plans together. Asset protection for a surviving spouse is important. You want to place assets in trust, maybe using a third-party trustee rather than your spouse. You may want to think about creating a life estate, which is spouse holds property for life rather than, and this is not a trust, holds the house for life and then it goes after their death to the kids. It's a way of keeping control of real property. You can provide for specific distributions for the spouse under what's called an ascertainable standard. It's a way of ensuring assets for a specific purpose and making sure there's some left over for example, a disabled adult child. A trust is a way for providing protections for children because both for disabled children and adult children, it allows you to control what happens for a period of time. How many of you would feel if those of you who have, regular teenagers, how many of you would feel really, really comfortable with having, let's say, $100,000 plop in the lap of your 19-year-old kid? Nobody? Oh, come on. If you died without a will or without a trust, that's exactly what would happen. Ooh, gee. That's not such a great idea. And by the way, you may have the most mature, sensible, intelligent, thoughtful kid in the world. And the kid is 20, and he's sitting in his dorm, and his girlfriend says, wouldn't it be really great if we went on a trip to Europe during spring break? But I don't have the money. How about you loan me some money, and we can do it together, and I'll pay you back? And the kid is going to say to his girlfriend, nope, I'm not going to loan you the money. Fat chance. But the kid can call his uncle and say, Uncle Trustee, can you loan my girlfriend money? And the trustee says, in a pig's eye, and your son can go back to his girlfriend and say, I called my uncle, and I cussed him out, and I begged and pleaded and called him every name except a child of God, and he still said, no, sorry. So it's not that you don't trust your kid, it's that you're giving your kid the ability to protect himself or from all these pressures that go on, and therefore you can delay the distribution of those assets to some future time. You can incentivize it. The kid gets money when the kid finishes college or 4 years of military service. So you got a goal there. You know, you can say that when you finish college, your uncle can use the trust money to help you put a down payment on a house. And we've listed some of that stuff in the material on how you can do that. I'm sorry, I keep kicking. You can also put in creditor protection benefits. And here's where your question becomes relevant. When you're dealing with a disabled individual and a disabled adult, or for that matter, a disabled minor, you're probably going to think about, if you're not actually accessing, means-tested government benefits. What does means-tested government benefits mean? It means that you're eligible for these benefits, Medicaid, SSI, if your income is below a certain level and your assets are below a certain level, and that level is really, really, really low. The woman here suggested $2,000 in her state. In D.C., we're a little bit more generous. It's $4,000. You can't do very much with $4,000. So what do you do to make sure, if your disabled child or if your disabled child becomes eligible to receive a whole lot of money, but you still want to keep those government benefits because some of them are tremendously valuable. Medicaid, some of these therapies that you all are talking about here, and these drugs that you all talking about here, and these doctors that you all talk about here are incredibly expensive. It doesn't take long to blow through $100,000. It really doesn't. And because I do some of this, I've seen it happen. So how do you protect that and still keep the child eligible for these benefits? You do it by means of what's called a special needs trust. And what that means is this. Remember I told you that trust is where you break apart ownership and use and enjoyment? So somebody owns, the child becomes eligible for a whole lot of money, medical malpractice action, an inheritance, an automobile accident, something that causes that child to be eligible for a whole lot of money, whether the child is a minor or an adult. Somebody owns that property, that asset, that money. It's titled in the name of somebody, but the child is the beneficiary of that money. The owner uses it for the use and benefit of the child. The child can't control it, can't direct it, can't insist that it be used for one reason or another. Child has no say-so about it. And with special needs trusts, and these are provided for by statute, the trust is limited to not paying for certain things. They're very tightly regulated, not paying for certain things, such as use for somebody else. The trust has to be used for the child's own benefit. They're loosening up a little bit for things like residences and housing and things like that. The Social Security regulations are very, very detailed, and they change all the time, so you do require some expert assistance on that. But it's the things that you can use it for are hugely expansive. Therapists, drugs that are not paid for by Medicaid, doctors and services that are not paid by Medicare, home health care. The list goes on and on and on and on and on. And therefore, these special needs trusts are critically important and beneficial when you're dealing with disabled individuals. You can set one up yourself using your money. You have to do it carefully and correctly, so kids don't try this at home. You need expert assistance on this. But you can put your assets in what looks and acts like a special needs trust for the benefit of your kid. Your question then about the life insurance is this. Your child is not the beneficiary of your life insurance policy. But the Jane Doe or John Smith Special Needs Trust is the beneficiary of the life insurance policy, you see. So it doesn't go to your child, and what you were told is right. If your child was the beneficiary and gets the life insurance benefits, all but $2,000 has to be used for their care. They lose eligibility until they spend everything down below that $2,000 limit. But if it goes into a properly constructed special needs trust, you can have, and they exist, special needs trusts worth millions of dollars, and the person is still eligible for SSI or Medicaid. So what's the catch? Why is this going on? Well, the government allowed these things to be set up because they recognize that in situations where you're dealing with a profoundly disabled person who has serious personal needs or medical needs, government can't possibly pay off for all of that. So if the kid does have money, you let the kid use that money for the kid's own benefit so the kid doesn't have to live in what is essentially a Charles Dickens-style orphanage. You know, nobody wants that. But on the other hand, we don't want to bankrupt our country for medical needs for disabled people. So the catch is this. These special needs trusts are called payback trusts. Section D4A of the Social Security Act, I forgot to write it down. It's 1928, I think, D4A. You'll hear them called about D4A trusts. These are called payback trusts. How does this work? How many of you remember the old Popeye cartoon, Popeye Olive Oil? There was a character, Wimpy. Remember Wimpy had a funny little hat? And Wimpy would run around and say, "I will gladly pay you Tuesday for a hamburger today." Remember that? That's Medicaid. Medicaid operates under the Wimpy rule. What the beneficiary says, the disabled beneficiary says to the government is, "I will gladly pay you Tuesday, when I die, for the hamburger health care today." These are payback trusts, which means that if at the time of the death of the beneficiary there's still money left over, the government can claim that money up to the amount that the government paid in Medicaid benefits for a period of time during the child's life. That's how that works. And that's why these things exist, and that's why they operate. These special needs trusts, some of them can run into literally millions of dollars. That's not the usual one, but it exists. There's another kind of special needs trust that I just want to mention, and then I'll take questions from you all, is a pooled special needs trust. And pooled special needs trust, some states have these, is a notion where sometimes you want to be able to protect assets, or the child has assets that need protection, but it may not be enough to justify the administration expense of a freestanding trust where there's a separate trustee that runs that trust. And unless you're dealing with a family member, you're going to have to pay a trustee, and even the family member is going to need legal assistance because these things are tricky. So it doesn't make sense necessarily to create a freestanding trust for a relatively modest amount of money. So what they came up with was this notion of a pooled trust that allows an entity, usually a nonprofit foundation or a nonprofit association, to hold money in a pool, invest the money, and manage the money as one big lump, but each beneficiary has a sub-account for their money. That account is managed separately, okay? Think of it in terms of if you had a whole bunch of bank accounts, well, you put them all together so you could get a better interest rate, but you kept the individual identity of each bank account separately, and that individual bank account is accounted for that individual. That's the way pooled special needs trusts work. And those are an option if you do have, or if your child comes into, grandma died and left a $50,000 life insurance policy, you can work it out so that money, rather than going to the child, can go into his pooled special needs trust and be used for the child's benefit. I think most states have them. Check with an attorney in your own state to see if that exists. Okay, I hope this is helpful to you. I hope I haven't been too general and not specific enough, but I'll take questions if yes. I unfortunately can't really speak to that, and I'll give you the two reasons. One is it varies tremendously from state to state. It really does. And secondly, I don't specialize in D4A trust, special needs trusts. There are lawyers who do that. There's a national organization of special needs trust attorneys who do nothing but that. And if in your state, you might want to see if you can access that. I'm sure you can find that doing some online research, or if you contact me, send me an email, and I can give you a reference to that national organization. And it's broken down state by state, and you know, Pennsylvania's a big state, so you know, look for what city or county in which you live, and focus on that. I should probably say, you know, just as a general matter, as I said earlier, even a will can be, if you're going to be dealing with asset protection, it can be tricky, it can be complicated, and you really should get expert assistance. I was talking to one of your foundation members earlier. People ask me all the time, can I write my own will? There's all kinds of stuff online and so on and so forth. And my response is, I have a colleague who's much politer about that. They say, well, yes, you can. And if things work well, that's fine. But if things go wrong, they usually go colossally wrong. And that's true. My response is, yeah, you can write your own will. You can also drill and fill your own tooth cavity. Have at it. As the people used to say for the kids shows, kids don't do this at home. Get some assistance. I'm not trying to gin up money for lawyers, because good lawyers, I don't sell documents, I do planning. Okay? If you want somebody to just sell you a bunch of documents, go to a mill. You can get a whole notebook full of stuff for, you know, several $100s. That may not meet your specific needs, and many of you probably have very, very specific needs that you need to address. The other thing is, tell people that you have them. These are not secrets, okay? I wish I had $1 for every time somebody comes into my office and says, well, Mom died. Did Mom have a will? I don't know. I mean, you don't know. In the same way that you want to talk to your family about your own wishes and desires, put them in writing, get your documents and say, I got these documents, and here's where they are, and this is where you can find them when you need to. It's not a state secret. You had a question? Somebody? Yeah. Or I'll repeat your question if okay, there they go.
Okay, if I were to outlive my disabled child, and I have assets left on my death, which I'm hoping don't plan on there being anything left over for anybody. But anyway, I have 2 other children, and what assets I have in my will are designated to them 50-50. I left nothing for my daughter, disabled daughter, because of the clause of the 2000 in the life insurance policy and that sort of thing. But anyway, so for her, if they were to not to take care of her, if they have her in a group home, and for her to get the benefits of Medicaid, then you're saying then I would have to have some kind of clause or a trust for her?
You would want to provide, and you may not need a separate trust. I'm not sure what state you're in, and what the Medicaid or SSI regulations are for your state. Medicaid and is a state federal program that, you know, the feds provide the money, and the states usually set up their own programs subject to certain limitations or directions by the federal law. You may not need a separate trust, but you need to have a separate provision for your child. Don't let the notion of what you heard about the life insurance scare you off. Just as a general point, you may want to reconsider your plan to leave everything to your 2 abled children and nothing for the benefit of your child, because at that point she's wholly dependent on government benefits, and that may not be the best alternative. You do have alternatives which you certainly should explore, and create what could be a special needs trust or arrangements for a pool trust for her benefit.
writing, the other two children have been told by me, obviously they need to take care of their sister.
Right.
I just didn't want, I just wasn't sure, because nobody's told me what you just told me about the special needs or the payback or any of that sort. Plus, she's also Medicare. Her father is retired and 69 years old.
The problem with that is Medicare. Medicare is insurance generally for senior citizens or beneficiaries for senior citizens, dependents for senior citizens. Medicare is very limited in terms of benefits for disabled individuals, and that Medicare doesn't pay for what's called long-term care or nursing home care. Medicare pays for medical care. Some of you may have had the challenges where you or a loved one has to go to the hospital and the hospital says, okay, they've been here for 3 days, they have to be discharged. Now, because Medicare only pays for services that require medical assistance, long-term care, group homes, or that sort of thing, isn't medical assistance as that's defined for the Medicare law. That's why you're dealing with Medicaid. It's a different program that provides different benefits.
I didn't want to sound like I was leaving her out of the picture altogether, but I just didn't know how to set anything up to have her to be able to have assets and taken care of without
And until they came up with this notion of a special needs trust, the problem that you are identifying is the wrenching choice that many parents confronted. You don't have to confront that anymore.
Okay.
There's an alternative.
Thank
Any
you.
other questions? Yes, sir.
Hi. I got a couple questions for you. With the trust and the special needs trust, does that only include the property that you have now, or you were talking about one of the trusts that you can change in the future as you come and go? So would like a special need trust, is that something that you have to change every time you buy a new property? Or?
No. One of the really cool things about trusts is you can add to them. One of the things that you want to do in your powers of attorney is to give your agent under your power of attorney authority to, if you become the owner of property and you're incapacitated, you want that agent to have the same authority that you could do to put money into your trust. The trust it holds assets, and those assets can go up and down. They can be added to, they can be distributed as money is paid out for beneficiaries. The special needs trust can either be a freestanding trust that you create now, separate from your own trust, because if you're creating your irrevocable trust, you haven't given that money away. And if you want to set up money now for the benefit of your disabled child, you can do that, but it may be better, and again, this is where you need specific planning help, specific financial advice. It may be better for you to provide for the assets to be distributed for your disabled child upon your death later. You can fund special needs trust in a variety of different ways. You could, your friend's example about life insurance is an example of that. You can buy a life insurance policy and make the beneficiary of the life insurance policy your child's special needs trust, the trustee of your child's special needs trust, and you can provide for your own trustee to pay for the insurance premiums on that insurance policy. There's a variety of really, really creative things that you can do to protect your child's interests, and you don't have to keep changing the basic structure, the basic trust document, because as it's written, it's going to be very, very flexible. Did I answer your question?
Yeah, and I got two more quick ones for you. State lines, when it comes to wills or trusts, does that affect anything if you get a will done in Maryland and you move to Tennessee, then you move to California? Does that have anything to do, or is it always going to be good?
I'm going to give you the answer that shows why people hate lawyers. Yes and no. Okay. If your will is executed properly, it will probably be good in every other state. Having said that, each state's a little bit different, and each state has laws that may impact on your will. Example, In the District of Columbia, there are certain rights that a surviving spouse has. You can put whatever you want in your will. The surviving spouse has those rights. There are certain rights that adult children have in the District of Columbia. You can put whatever you want in your will. Those kids have those rights by statute. Maryland, and I practice in those two jurisdictions, doesn't have that same structure. Maryland, on the other hand, has a different structure which allows a different set of spousal rights to take effect even for a trust. Usually in D.C., the spousal and child rights deal with the probate estate. If it's not in the probate estate, they don't have those rights. In Maryland, they do. So if you were to live in Pennsylvania, have a Pennsylvania attorney put together your documents, and then you move to Tennessee, they may still be perfectly fine. But you might want to have an attorney in Tennessee look at them and say, yeah, they're okay, they're no problem here, or you need to tweak it a little bit to match Tennessee law, which is why if you're going to do one of these trusts, do a revocable trust, because you can change it. It's easy. Okay.
And can you do that with a special need trust too? Where you can change, or is that more?
Generally, no, because those are irrevocable trusts. Once they're set up, they're usually fixed. They're not easily changed, which is another reason why you might want to postpone the actual funding of a special needs trust with your own assets until later on down the line. And you can do that. You can direct that in your own estate plan. Okay? Did I answer your question?
Yeah. Oh, and one other question real quick. I know you're local, and I actually work not too far from your office. So if we were to use you to set this stuff up, how much would it cost us? And do we get a discount?
Tell me you were here. There's a couple of different reasons why I really am reluctant to quote fees. I will tell you, you can find lawyers who are much more expensive than me. Honestly, you can find lawyers who are less expensive than I am. I would suggest, and I'd be happy to talk to you, I have a free consultation policy, and it would depend a lot on what you do. I believe that people should be able to talk to a lawyer at least once and not have to pay for it. And I've always practiced that way, and many of my colleagues do as well. But I would, in all candor to you, shop around, talk to me, talk to somebody else, have the right fit, and then go ahead.